सर आपकी मुस्कुराहट इंगित कर रही है कुछ। मैं ये कहना चाह रहा था सर, और मैं समझता हूं कि ये बात मैं कह करके, और 239AA के बारे में जो बातें कही गई हैं मैं उसको दोहराना नहीं चाहता। सिर्फ मैं एक चीज पे आऊंगा, कोरम। सर ये कमाल का कोरम हुआ, 3 में से 2 होंगे। मुख्यमंत्री बेचारा चेयरमैन है, बहुत अच्छी बात कही उन्होंने, चेयरमैन विदाउट चेयर। मुख्यमंत्री चेयरमैन है, वो अगर 2 मिनट लेट भी पहुंचेंगे तो कोरम डिसाइड कर लेगा क्या करना है दिल्ली के लिए। सर इट इज नॉट कोरम, it is actually an instrument to decimate the very idea of elected government. सर सर कंटिन्यू हो जाइए, केशव राव जी की श्रेणी में 1.5-2 मिनट और ले लूंगा। सर एक सोल डिस्क्रिशन का मामला आया है, सोल डिस्क्रिशन, और ये मैं आग्रह करूंगा माननीय गृह मंत्री जी से, हमारी महामहिम राष्ट्रपति के लिए भी जो संदर्भ आते हैं ना, टू एड एंड एडवाइस ऑफ द कैबिनेट और द मिनिस्ट्री, सर उनका भी सोल डिस्क्रिशन नहीं होता है। ये तो एक तरह से मुझे सोललेस डिस्क्रिशन दिख रहा है, आत्मा विहीन डिस्क्रिशन। सर ये उसमें नहीं फिट बैठता है। सर एक और चीज, मैं अभी कल गूगल कर रहा था सर फेडरलिज्म पर, 2 बहुत महत्वपूर्ण कोट मिले इंटरेस्टिंग लोगों की, एक चंद्रबाबू नायडू जी का, एक नवीन पटनायक जी का। वो कोट मैं पढ़ना नहीं चाहता हूं, बस मैं बता देना चाहता हूं। आखिरी सर, ये पेशे नजर तमाम लोगों के जो कहते हैं, अपील करते हैं कि साहब मदद करो इस बिल पे, तो दुष्यंत जी कह के गए थे कि उनकी अपील है कि हम उनकी मदद करें, चाकू की पसलियों से गुजारिश तो देखिए। सर ये चाकू पसलियों से कह रही है हमारी मदद करो। सर ये आसान मामला नहीं है। जय हिंद सर, जय हिंद।
Kareem.
Bigash is speaking, sir. Bigash, I was given the name. Bigash Bhattacharya. He is speaking for CPIM. CPI, for CPIM, Bigash Bhattacharya is speaking. I have given the name.
Achha. Vikas Bhattacharya. Vikas ji,
Chairman, sir,
7 minutes.
I will finish before that.
Yes.
The 7 minutes starts from here. Sir,
They end here.
we are all rational animal. Human is rational animal. The difference is rationality and animality. This rationality has driven us to move forward. The human civilization has advanced step by step. We have never seen that the civilization has gone backwards. When the Constituent Assembly was discussing about the Constitution, you are well aware the role of governors were discussed. It was decided upon discussion that governor cannot be another source of power. Governors should act following the advice of the elected representatives and the representatives of the government. This is a settled principle. And on the basis we have advanced to a people's government where the governor was an ornamental constitutional head to keep liaison with the center. The basic principle was that the federal principle and federal governance as per our constitution is carried forward. When the constitution was adopted, then Delhi was not a state. That was the union territory. Like many others, I am not going to give examples. That rationality has driven us to go forward and advance to the stage that the Delhi would be a state with certain restrictions. And the people will have the right of governance through their representative. This was the advancement of the Constitution. That's why the Constitution Amendment and 239AA was incorporated. Now what we see, we find today that we are going backwards. The governor or the bureaucrats, they are bound by the constitutional principle and constitutional morality to be answerable to the elected representative. That is the republic. That's the republic, democratic republic, the constitution makes us thought of. No question of this party and that party. That was the result of independent struggle I know some people did not have the legacy of independence struggle. They might have a different outlook, different thought. But this representative government is the outcome of independence struggle which the people fought, giving their lives, sacrificing lives, not surrendering their own right at the behest of the British mercy. Now, what this rule is, what this bill for? Bill is sought to replace the ordinance. Why the ordinance came for? Let us analyze stage by stage. I am not going to have a quarrel with this party or that party. The House is for discussion of the constitutionality of this bill. Nobody questions the power of Parliament. Having power is one thing, but exercise of power is wisdom. Unless you have the wisdom, the power gives you absolutely autocratic authority, which is against the basic principle of our constitution. Sir, have you noticed you were the governor and you felt that in spite of the best of your desire, you have to be bounded by the aid and advice of the government. That was your practically frustration, that without the aid and advice of the government, I cannot do anything. Because the constitution thought of, again I repeat, the representation of the people. People is the last word. They have chosen, might be XYZ to your liking or not liking. In the Delhi bill, have you seen? I have never seen. The Constitution of India, the Supreme Court had said, even the President of India doesn't have unguided discretion. And here, by a law, Parliament will say, you have a sole discretion. Would the Parliament invite the autocracy? This Indian Parliament, this law invites autocracy. This law speaks of throw away the people's government. I appoint a bureaucrat, I appoint somebody of my choice, he will dictate. You will be subservient to this. Have you gone through this bill? This bill would take us to completely the stage of animality, not the stage of advanced humanity for which we feel proud of. We, the people of India, we thought of governance. I was reading this bill. It reminded me the 1926 Act of Kolkata Corporation, where the executive was the superior. Mayor was just a subservient force. That was thrown away by the people. Now, here also, we have, under the Constitution, created third tier of government. Democracy means distribution of power. Democracy means not centralization of power. These bills only empowers a particular individual. He might be a wise man, but maximum power without any guidance would lead him to an autocrat, not less than the Hitlerite autocracy, which will take us to a doom. I have already submitted. Here, everybody has said, the Chief Minister is nothing but a puppet. Puppet of whom? The bureaucrats. Bureaucrats will dictate and Chief Ministers to follow. Is this the way you respect the constitutional principle and morality? Here the bill says, and in fact, this bill is total amber, reading through the clauses, abdication of the governance by the people's representative. I would request all, don't be guided by your petty political feeling. This will lead to a situation, tomorrow I will say the Orissa government, Orissa Chief Minister has to be subservient to the governor, I pass rule. What would you do? The Home Minister's praise in the meeting would not give you result. They will say there is a precedent. Parliament has passed such a law. Lord, you have already given me a caution. I said I will finish within the time. I'll finish with the appeal to everybody, even to the Treasury bench. Don't be trapped with such a bill which ultimately will kill you. Don't make the democracy absolutely a farce. Let the representative government survive and the principle be extolled by the constitutional principles. With this, I appeal to you, reject this bill. I appeal to you to all, reject this bill.
Thank you. Very good.
Shri Anil Prasad Hegde. 7 minutes. 1 second.
I'd like to say, there are a couple of references that have been made to Honorable Chief Minister Shri Naveen Patnaik ji. He is not a member of the House. So any remarks thereof may be kindly examined and discussed. One, sir. Sir, I'm not done. I'm not done. The second is a reference. The second, sir, I'm not yielding. I'm not yielding, sir. I'm not yielding. The second is with reference to the Odisha government, sir, as well. We are open to discussions on that. We can talk about 239 AA and why it only serves the Delhi government, because Delhi has a special place, is sui generis, which has been provided by Supreme Court. Therefore, to talk about any other government is not appropriate. The same may kindly be examined, sir.
I will examine and
Sir,
take a call.
thank you.
Shri Anil Prasad Hegde, 7 minutes.
Thank you, Chairman.
7 minutes, 7 minutes. 7 minutes.
Thank you, Chairman. I am rising on behalf of my party.
When there was a time for you to say so, Mr. Siva, you did not say so. And now you are saying so. I pleaded with everyone to say so. Mr. Hegde, 7 minutes. I'll take care of it.
Thank you, Chairman. I am rising on behalf of my party to strongly oppose this bill. At the outset, I want to make it clear that this bill, which seeks to ratify an ordinance, has dealt a severe blow to democracy and cooperative federalism. Sir, the union government is usurping the powers of the state by blatantly bulldozing through laws on subjects in state list. The government is also bartering the sovereignty of this country, sir. यह विधेयक दिल्ली का मुख्यमंत्री और 2 अधिकारियों को मिलाकर नेशनल कैपिटल सिविल सर्विसेज अथॉरिटी का स्थापना करेगा, जिसमें सिर्फ 2 लोगों का कोरम से इस अथॉरिटी का मीटिंग संभव है। इसका मतलब दिल्ली का चुनी हुई सरकार को काम करने, निर्णय लेने के लिए दिल्ली के लोगों ने जो अधिकार दिया है, इस अधिकार को 2 अधिकारी लोग एलजी का सहमति से छीन लेंगे। सर, ये कैसे अनडेमोक्रेटिक है? सर, पिछले सप्ताह इसी सत्र में बायोडायवर्सिटी एक्ट और फॉरेस्ट कंजर्वेशन एक्ट संशोधन बिल पास हुआ। ये बायोपायरेसी को बढ़ावा देगा। बायोडायवर्सिटी एक्ट में जेपीसी द्वारा किया गया 21 रिकमेंडेशंस में से 20 को दरकिनार करके पास किया गया है। सर, फॉरेस्ट कंजर्वेशन एक्ट is opening up precious forest resources to the exploitation of private companies, sir. To illustrate my point on sovereignty, sir, पर्यावरण कानून उल्लंघन के लिए जो जुर्माना होता था, इसको समाप्त करने के लिए एक लंबे अरसे से अमेरिका को एनवायरमेंट प्रोटेक्शन एजेंसी और बहुराष्ट्रीय कंपनियों का मांगता बिल पर ये बोल रहा हूं, जिसके बारे में मेरे पास प्रमाण है। पिछले सप्ताह यहां पर बायोडायवर्सिटी संशोधन बिल पास करके उन लोगों को उनका मांग को पूरा किया गया। सर, ये दिल्ली के बारे में ही बोल रहा हूं। जब जैसे कैसे अनडेमोक्रेटिक है मैं बोल रहा हूं, विडंबना है यह है बिल। सर, पिछले 3 महीनों से मणिपुर में लगातार सामुदायिक हिंसा चल रहा है। इस संदर्भ में सर्वोच्च न्यायालय ने कॉन्स्टिट्यूशनल मशीनरी संपूर्ण ब्रेकडाउन बता रहा है। मणिपुर के मुख्यमंत्री को बदलने के बजाय दिल्ली में जहां पर सब कुछ ठीक है, यहां पर का कॉन्स्टिट्यूशनल मशीनरी में संशोधन लाना विडंबना है।
ऑनरेबल मेंबर, बोलिए।
मैंने बताया सर,
ऑनरेबल मेंबर,
स्टेट लिस्ट, स्टेट लिस्ट।
1 second. You are a senior person,
sir,
knowledgeable person.
Sir,
you have to confine to the issue at hand.
I was talking how this is undemocratic. I was saying to drive home my point, how the bill is undemocratic. I was giving an example, sir.
Confine.
मैंने बताया सर, ये बिल स्टेट लिस्ट में राज्य का अधिकार को छीना जा रहा है। सर, कृषि स्टेट लिस्ट में है सर। उदाहरण के लिए मेरे दल के मुख्यमंत्री नीतीश कुमार और दिल्ली के सरकार, दिल्ली के आम आदमी का सरकार जीएम मस्टर्ड और जीएम क्रॉप्स का विरोध किया है, जैव परिवर्तित फसल को। लेकिन पहली बार खाद्य क्षेत्र में जीएम फूड क्रॉप्स में दिल्ली यूनिवर्सिटी का DMH 11 जीएम मस्टर्ड को 25 अक्टूबर 23 को केंद्र सरकार अप्रूवल दिया है। विदेशी कंपनियों को खाद्य क्षेत्र में जैव परिवर्तित फसलों को लाने के लिए दिल्ली यूनिवर्सिटी ट्रोजन हॉर्स बन के रास्ता साफ किया है सर। सर
Go ahead, go ahead, go ahead.
बोलो बोलो अनिल भाई बोलो, जोर से बोलो
सर
अरे विकास चलो चलो आगे चलो।
सर 1 मिनट सर मैं जो आपको अभी सॉवरेनिटी के बारे में मैंने बताया, उसका एक मैंने आपको पढ़ के बताता हूँ एक लाइन। सर ये यूएस का एनवायरनमेंट प्रोटेक्शन एजेंसी का जो वहाँ का बराबर है, जो मिनिस्ट्री का बराबर है, ये बताता है कि this dialogue should be preceded by an analysis to be developed by EPA of India's current and relevant statutory provisions with a discussion of these interpretations and application in civil cases as well as specific recommended changes in the constitution। देश का संविधान में को बदलने के लिए अमेरिका हमको कह रहे हैं सर, और environmental statutes, regulation that are necessary to establish civil judicial authorities। सर मैं इस बिल को मेरे पार्टी विरोध करता है सर।
श्री जोश के मनी 4 minutes. 4 minutes.
Thank you, sir. I raise to oppose strongly the Government of National Capital Territory of Delhi Amendment Bill 2023. As said by my colleagues, it is anti-democratic, anti-federal, and it is aimed to distract the proper functioning of the democratically elected government of Delhi. When you talk about democracy, it is centered around the other people. It is made for the people. But this bill is formulated by the bureaucrats, of the bureaucrats, and for the union government, which means the people are eliminated and the essence of democracy is vanished. Yes. The bill is nothing short of a disgraceful attempt to snatch the power from the hands of the people. The way the ordinance was sneaked in without any valid justification is nothing short of the abuse of power. Very bad. What is the objective of this bill? What is the emergency of passing or creating the ordinance? It is only a politically motive gain. The bill undermining the very essence of parliamentary democracy and the right of its citizen. It undermines the state's right and authority, turning Delhi into a mere puppet under the central government control. Yes, sir. The provision of the Honorable LG's sole discretion on matters recommended by the National Capital Civil Service Authority is a cruel joke on the concept of autonomy and self-governance. The bill is another betrayal of our democracy and federal system. So the bill is a systematic death blow to the democracy, is what achieved by this legislation. The central government, with the majority which they gained by decisive strategy, is now chopping the branch they sit. So we can cite a number of cases like, to establish this newly, the various bill which is passed in the parliament, the multi-cooperative society bill, the agriculture bill, and also the intruding upon the sovereign domain of the state, and so on. All these are trying to crush the federal system of our country. Exactly. The bill also adds to the list of actions undermining the federalism in the country. Basically, we understand that BJP is not able to get the power of the state of Delhi from the people of Delhi democratically, that is through election. Hence, they are trying to curb the powers of the state government. The only question is, if BJP was in power in Delhi, would they accept this bill? I am sure that they will never ever think of it. Let me conclude by saying this bill and the ordinance is an insult to the spirit of the nation. This legislation I will vehemently oppose until justice prevails. Thank you.
Shri Abdul Wahab, 4 minutes. Shri Abdul Wahab, not present. Shri P. Chidambaram, Shri P. Chidambaram, not present. Shri Mahesh Jethmalani,
Honorable Chairman, I rise to support this very, very important bill. I'm not in court and I'm surrounded by you.
can I persuade you to yield in favor of Mr. Chidambaram?
Ah, yes, of course. I was actually supposed to speak after him.
No. Call has been taken by the chair. Shri P. Chidambaram,
I'm just looking for the time.
9 minutes. There is a request from your party.
15 minutes.
All right. Sir, my good friend Dr. Abhishek Singhvi has marshaled the legal arguments and placed the facts before this House and appeal to them, appeal to the House and appeal to the Treasury benches not to proceed with this bill because this bill is unconstitutional. Now, I can understand the full-throated support given by the BJP, but what I do not understand is the half-hearted support extended by two of my learned friends representing the BJD and the YRCP. They know that this is unconstitutional. I think the law ministry knows it is unconstitutional. It's like a moth which burnt once when it approaches a fire, again approaches the same fire, and again approaches the same fire because it's a moth. Now, this government tried it once, it failed. It tried it a second time, it failed. And you're trying it a third time. I wish you what you will get, a spectacular failure when this bill is taken up. Be that as it may. I'm not getting into the legal arguments because we are not a court of law, nor, I'm sure, anyone in the chair wants to be a judge. We are the Council of States. We are duty-bound to protect the rights of states, rights of union territory. We are not representing an individual parliamentary constituency. I'm representing a state. Each one of my learned friends is representing a state. And collectively, we should represent all the states of India. What are we? Are we a union of states Or are we going to become a union of moth-eaten states? Or a union of moth-eaten union territories? Or a union of municipalities? Please remember the old dictum, no taxation without representation. That's the fundamental premise of a representative and parliamentary democracy. Delhi has, according to the figures I sourced today, 3.17 crore people. Now the 3.17 crore elect a government. They elect a government to govern them, to take decisions on their behalf. The underlying premise is we are a representative and parliamentary democracy. You may ask me, where are those words in the Constitution? Those words are in the Constitution. The magic words are that there shall be a council of ministers with the chief minister at its head to aid and advise the lieutenant governor. The words aid and advise is not some kind of a friendly advice. Aid and advise has a long constitutional history. Aid and advise means the real power is in the Council of Ministers. The LG exercises formal power. The real power is with the ministers of the government. The formal power is with the President of India. Aid and advise is magical words. What we are doing today is subverting the three magical words, aid and advice. Now, people are watching us. It's not only the 200 odd members in this house. People of Delhi are watching us. They will watch us today on television, on YouTube. They will know that this government is attempting to take away the real power of the elected representatives and put it in the hands of bureaucrats. Now, I asked in a tweet, and I'll ask this question. What is the merit you file with the bill? Leave alone the constitutional aspects. What is the merit you file? Is there merit in a three-member authority where two officers will constitute a majority and overrule the chief minister? Is there merit when two members of the three constitute a quorum, they can even call a meeting, hold a meeting without the chief minister? Is there merit that even if a decision is taken unanimously, the LG can overrule it? Is there merit that the member secretary, who is the principal secretary of Home, will convene a meeting with or without the chief minister? What is the merit? What is the merit? I heard you on television. I heard the honorable member on television. I didn't find you mention any merit in any clause of this bill. I heard you also. And I was even more disappointed. Therefore, what is the merit? What is the merit? What is the merit? What is the merit and what is the merit in this clause?
They are sitting in the opposition.
What is the merit in any clause? There is which clause has any merit in it?
I would urge the honourable member to get into a groove that
We are
does
not
not
getting into the
invite.
constitutionality. I'm saying, irrespective of the constitutionality, which clause has
Sir,
any
you went on a
merit in it?
tangent, physically and thoughtfully. Therefore, the honourable member had an occasion to be on his feet. I would urge you to confine to that limit.
Very well, this is my view.
It is expected of you, sir.
No, I have great respect for their view. All I'm saying is, I didn't find them point out the merit in the clause of the bill irrespective of the Constitution. So we have a bill today which the government thinks is the model for Delhi. They had invented a model for Jammu and Kashmir, and that is in court today. Please remember, we always talk about breakdown of the Constitution of India, breakdown of constitutional governance. Article 355, 356 speaks about breakdown of the constitutional machinery. What are we doing today? We are breaking the constitutional machinery. By passing this bill, by passing this bill, by passing this bill, we are breaking the constitutional machinery as envisaged. We broke it on 5th of August 2019 in Kashmir, divided a state into 2 union territories, and sending a chill in the spines of every state that any state can be broken into union territories. What are we doing today? We are breaking the constitutional machinery. Sir,
Honorable member,
let me end by saying, while I endorse whatever my good friend Dr. Singhvi said about the constitutionality, and there is another forum which will argue, please remember, you have no constitutional authority to pass this bill, be that as it may. You have not even a moral authority to pass this bill. The treasury benches, when did they last win an election in Delhi? 15 years, Mrs. Sheila Dikshit was chief minister. I think there were 2 or 3 lieutenant governors.
Please
1 minute.
conclude.
2 or 3 lieutenant governors, and I was home minister for a while. Never once did the present present arrangement come in the way of Mrs. Sheila Dikshit functioning as perhaps one of the best chief ministers of this country.
Shri Mahesh Jethmalani.
Just one minute.
Thank you.
I asked you before I started, you said 10 minutes, therefore I'm speaking. It's not 10 minutes yet.
It's 9 minutes.
It's 9 minutes. It's 9 minutes.
So it's
not
You
10
said
minutes
if
as
I...
Sir, my
Now,
problem is
when did the
that
BJP...
everyone needs support of Jairam.
When did the BJP last win an election? They won an election before 1998. 1998 to 15 years, Congress government was there. And after 2013, it's the AAP government. You won an election 25 years ago. What moral rights have you to speak for the people of Delhi and say this is what the people of Delhi want? This is not what the people of Delhi want. This bill must be rejected.
Shri Mahesh Jethmalani.
Honorable Chairman, I rise to support this bill.
1 second. Sir says it's getting louder. Decibel level has to be, is getting louder, sir. Yes, Mahesh Jethmalani.
Sir, Dr. Singhvi, in his opening remarks, said that he made a lot of uncharitable comments, that this was a bill, hunkar ka natija, his exact words. He also said that we were Alice in Wonderland, constitutional arrogance. All these words were used, but I found very little in his speech regarding the legality or the constitutionality of this bill. I reminded about your Lordship, my Honorable Chairman. Very difficult to wear 2 hats on the same day. Honorable Chairman will recall, with all his eminence at the bar, there's an old saying.
You are the 3rd senior advocate.
Yes.
I am listening for the day. And trust me, I will go home and read every word of each of you have said and privately get back to you.
It will be a deja vu moment for you. Anyways, we used to have an old saying in court that when a lawyer is strong on the law, he hammers the law. When he's strong on facts, he hammers the facts. When he's strong on neither, he hammers his opponents. A lot of that has happened today. Now, so I come to as Mr. Chidambaram has said that he'll not deal with the law in this matter. I don't blame him. For some time now, he's forgotten about law and compliance. So I don't blame him. Now, sir, let's come to the constitutionality of this bill. So the constitutionality of this bill is to be found in the Constitution itself, and that is 239AA. And I'll just read one provision. It may be a little pedantic for most people, but I'll just read. After all, sir, the Union Territory of Delhi is sui generis. The Supreme Court has said so in the 2023 May judgment. But when it said it was sui generis, which means unique, it meant that it was a sui generis union territory because it was the only union territory which had the privilege of having both a state legislature and a council of ministers. It is not a full-fledged state. That may be unfortunate. It is a sui generis, i.e. an escalated union territory with more powers than other union territories. Now, the provisions of the Constitution reflect that. If I may just read one article or one sub-article, 3B. Nothing in subclause A, which is the powers of the Union Territory of Delhi to legislate. It says, nothing in subclause A shall derogate, which means depart from, the powers of Parliament under this Constitution to make laws with respect to any matter for a union territory or any part thereof. Now, look, this is wide. Sir, this is wide. This is widespread. This is all-encompassing. It covers union list, state list, concurrent list. The union government can make powers, notwithstanding that there's a vacuum, on any matter in any of the three lists. So the ultimate power of the Union Territory of Delhi still vests, notwithstanding the fact that it's a sui generis union territory, ultimate power vests in the union. That's point number one. Now, so what does the bill do? This really is a battle about control of services. It never arose in the past when Sheila Dikshit was the Chief Minister of Delhi, a reign which Mr. Chidambaram proudly flaunts. There was no question that she never thought that it was necessary to give Delhi full statehood in all the 10 years that she was in power. She never gave Delhi full statehood. Apart from that, she never thought it was necessary to have a provision like this because since times immemorial, and particularly since 1991, when Delhi got that sui generis status through 239, ever since it got that, it was almost accepted. It became a matter of convention that the powers of control over the services would vest in the union. And it did in fact happen. That was because the seat of government is New Delhi, of the union government. Parliament is here. Foreign diplomats are here. Embassies are here. So the seat of power being in Delhi, control over services in Delhi vested in the union government, and it passed muster over successive administrations. It was never questioned. Now, what does this bill do? This bill actually reflects the sui generis union territory status of Delhi. And I'll just read one provision. 45E is crucial. In the matter of transfer of postings, postings and transfer of the services, 45E creates a new body. It creates a body, an authority, known as the National Capital Civil Service Authority, to exercise powers conferred on and discharge the functions assigned to it under this part. Now, that body, the constitution of that body, reflects the sui generis nature of the Union Territory of Delhi, as also the fact that the ultimate control rests in the union government. So, the authority referred to in subsection 1 shall consist of the following members, namely, the Chief Minister of the Government of National Capital of Delhi, who shall be the chairperson of the authority ex officio, and the other 2 members will be, so the chief minister of the government of the National Capital Territory of Delhi is the ex officio chairman of the authority that will deal with postings and transfer. The Chief Secretary of the Government of National Capital Territory of Delhi member will be ex officio, and the Principal Home Secretary, Government of National Capital Territory of Delhi, will be the member secretary to the authority. So, the three-member authority will consist of the Chief Minister and 2 high-ranking bureaucrats from the center. This authority fully reflects the nature of the relationship between the Union Territory of Delhi and the Union government. This is reflective of that. Now, sir, what is the reason for this departure, if I may say so? This has been going on, as I said, since 1991. Control postings of services is within the jurisdiction of the Union government. I see none whatsoever. The only change of circumstances that seems to have taken place, if I may use an analogy from cricket, with the respective parties who are chiefly concerned with this change, AAP, Congress, and the BJP, is that the Congress, who never had any problem with this issue about control of services, has now, like a batsman who has lost form and hasn't scored a half century for 10 years, is now seeking an alliance so that it can inch towards its first 50. The AAP is like a cricket team whose captain has been caught ball tampering. A vigilance report exists, and suddenly they want to become vigilant about the vigilance report. The BJP's present government is the third umpire. We want to stop this nefarious practice. A convention, a wholesome convention for better administration and for effective administration of the Union Territory of Delhi by the Union government now needs to be made into law, lest people subvert the services and hide their corruption. I wholeheartedly and with all the vigor at my command support this. Thank you, Chairman.
Shri Abdul Wahab, 4 minutes. 4 minutes.
Yeah, for me is more for me. Respected Chairman Saab and my colleagues are telling more about this Delhi bill. I don't have much to add to that one. My only wish is, this is only for 8 months business. Next government is of India. So everything what is happening here will negate. And Amit Shah ji thinking that he will be always the Home Minister only. You don't want to be Prime Minister also. So the next Prime Minister already announced, 3rd term I am the Prime Minister. Modi ji was already told. So what is the need of this bill, thinking that I will be always Home Minister? So my request is to take this bill, and anyway it is going to be negated by the next government of us. It is for sure. Yes. So India will be ruling, all this will be null and void. So my request to Amit Shah ji, at this point of time, don't be in the history, don't be a villain instead of a hero. So what happened in Kashmir?
This word is not good.
Wedding is not, no,
Using a word villain.
Sorry, I am myself taking
you
back.
You see, all of us.
I am withdrawing.
One second. All of us have to exemplify our conduct.
Yes.
So that it could be emulated by others.
Yes.
It is good of you.
I took back.
It is good of you to take snipe shots, but in the process, maintain decorum.
I didn't mean
and
that.
And dignity. Go ahead. It is expunged.
Yes.
Go ahead.
So, my request to Amit Shah ji, It is happened in Kashmir and in here and maybe in Punjab tomorrow. I don't know. So whatever is happening in our immediate solution should be in Manipur and Haryana and other places. So I request Amit Shah ji to interfere in Manipur more than in Delhi affairs, small affairs. Some officers changing this and all. But this gentleman, our chief minister, came as a, what you call, I am telling, as a hero. I was thinking that they are the B team of BJP before I was thinking. But now only I came to know they are not the B team of BJP. They are also want to rule Delhi as a chief minister. So I stop this one asking again to Amit Shah ji to repeal this bill. Thank you.
Shri Ranjan Gagoi. Honorable members, it is the maiden speech of the honorable member.
I thank the Chairman, sir, for the opportunity. It's a great day. A maiden speech on a subject that is very dear to my heart and a subject that can be as related to law as possible. So a maiden speech, I believe the chair is a little indulgent and gives a little more time, but I won't take much time. A maiden speech also has the protection of the House. It is freedom of speech in an absolute form. The member has a right to say on the first day whatever he wants. So, I would confine myself to the legality of the proposed legislation. And I will address the House and the Chair, of course, from three standpoints: sub judice, overreaching the Supreme Court's order, and the constitutional validity. So there is some faint voice about impropriety, sub judice. As a layman, it is not sub judice. What is pending before the Supreme Court is the validity of the ordinance. What the House is debating is on the validity of a law.
Please. Would you please take your seat? No. Absolutely no. 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 Don't force me. The House was going well.
This is the replacement of that ordinance. No.
One second.
No, there is a difference.
All right.
Do you want me to go further? Please take your seat.
Mr. Chairman, sir.
I will not allow. This is not good.
Mr. Chairman, sir.
Interrupted. You suddenly rise. The House is getting enlightened. Trust me. Mark every word. The House is getting enlightened, as was enlightened by others also. Please go ahead, sir.
Mr. Chairman, sir. What is pending before the Supreme Court is the validity of the ordinance, and specifically two questions referred to the Constitution bench. That has nothing to do with what is being debated in the House, number one. Number two, this is for all the members of the House, and it has some importance so far as the relation between the judiciary and the executive is concerned. I would request all the members of the House to have a relook at Articles 105, 121, and 122. There is absolute freedom of speech in Parliament, and whatever a member says in Parliament cannot be questioned in a court of law. I do not find a similar constitutional provision restricting the debates in courts. What the courts cannot do under 121 is question the conduct of a judge in relation to a pending matter. The restriction that the House imposes on its own speech is self-imposed by the rules. And what do the rules provide? Mr. Chairman, sir, the rule says a member shall not discuss a matter of fact, which is a court pending before a court of law. It's not a matter of fact that is what is being debated. It's a question of law. It is not even an interpretation of law. It's on a debate on law. Now, Mr. Chairman, sir, so where as sub judice is concerned, the bill takes away 3A from the ordinance. To my mind, it's a perception, I may be wrong. To my mind, when 3A has been taken out of the ordinance and it is not there in the bill, the questions referred to the Constitution bench stands self-answered. Because if you read the order of the Supreme Court referring the matter to the Constitution bench, a copy of which I have got and I have read, my view is that the entire reference has been necessitated by the provision of 3A of the ordinance, which no longer exists. Therefore, it is the prerogative, the right of the members of the House to debate. The question of sub judice doesn't come. So far as overreaching or outreaching the order of the court, Supreme Court is concerned, very shortly put, the position in my perception is this. The state legislature makes laws for the states, the parliament makes laws for the union territories. For the National Capital Region of Delhi, which has a special status, the state legislature or the legislature of Delhi makes the laws on the state subjects, except 3. But as Mr. Jethmalani read out, by virtue of 239 3B, Parliament has a power to frame laws beyond these 3. And that is exactly what the bill is seeking to do. Therefore, there is no question of overreaching. And what has the Supreme Court repeatedly said? Paragraph 164, 2 conclusions. These are the 2 conclusions. May I read out these 2 conclusions? The legislative 164C, the Legislative Assembly of the NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries. In addition to entries in List 1, in addition to entries in the Union List, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD. This is the conclusion in paragraph 164C. Paragraph 164F, the executive power of the NCD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. So this is the conclusion of the Supreme Court. And therefore, now, what has the Supreme Court repeatedly held in the 2018 judgment and the 2023 judgment? Precisely this. And I'm very grateful for the fairness shown by the first speaker, Dr. Singhvi, if I am not mistaken, what Dr. Singhvi said, the power of Parliament is not in dispute. He said it very fairly. The power of the legislative competence of Parliament is not in dispute. Then why would this law be bad? This law would be bad if it violates the fundamental rights, number one. Number two, if it violates any other provision of the Constitution, and if it violates the basic structure of the Constitution. Right.
Honorable members,
yes.
I don't have to remind honorable members, it's a maiden speech. Yes, please. And the honorable member is making his point very rationally.
Sir,
it is one point of view.
I will take.
Well, the chair has taken a call.
I will take 2 minutes.
Here with it. Sorry.
You have 15 minutes. You have 15 minutes.
Should we?
So far as
One second.
Fundamental right is concerned.
Honorable member, one second.
Yes.
The member on the maiden speech.
Yes.
And I had every time pleaded with you to show respect. Merely because what the point is
14, and that too the limited part of Article 14, that the law is arbitrary. Is this law arbitrary? This doesn't appear to be so. The law may not be to my liking. That does not make it arbitrary.
Absolutely.
Next, does it violate the basic feature of the Constitution? I have to say something about the basic feature.
Please.
There's a book by Mr. Andarajuna.
Yes.
The former Solicitor General, on the Keshavananda Bharti case.
Yes.
Having read the book, my view is that the doctrine of basic structure of the Constitution has a very debatable jurisprudential basis. I would not say anything more than this. I wouldn't say anything more. The doctrine of basic structure has a very debatable jurisprudential basis. In any case, Honorable Chairman Sir, what the bill provides, what is the bill? Federalism. Because it's a union territory, not a full-fledged state. Therefore, what you have is a diluted form, an asymmetrical form of federalism. And the third thing is, does it violate any other part of the Constitution? The Supreme Court mentioned about triple autonomy. What you have under the bill is a modified form of triple autonomy. The bureaucrat is responsible to a lieutenant governor, who is responsible to the Home Ministry, who is responsible to the House. You have a modified form. If you want a full-fledged federalism, which today is a basic feature, though I have my own perceptions there, you can go for an amendment, for a constitutional amendment, and make Delhi a full-fledged state. Now, the most important thing, Chairman Sir, is Article 239AA, starting from 1 to 7, is not under challenge before the Supreme Court. Challenge it. That is not under challenge. Therefore, in my respectful submission, my contention, the bill is perfectly legitimately valid. But I fully support Mr. Vikas Bhattacharya, who has been a very close associate of mine. What is permissible need not necessarily be right. In the House today, parliamentary democracy compels members to vote according to party dictates. Fine, I cannot quarrel with that. It's a small section of people to whom you appeal to their conscience. To me, the bill is correct, right. My conscience tells me to do something, I'll do it. But if somebody disagrees, his conscience must be left free. Thank you. I am honored. I'm privileged.
Well, we have one thing in common. Dr. Vikas Bhattacharya is also my good friend and known to me for long. And I remember when he was mayor of Kolkata Municipal Corporation. Dr. Fozia Khan.
Thank you very much, sir. Sir, I wish to express my profound concerns and my vehement opposition to the bill, sir. This bill, as said by many of my colleagues, raises many constitutional apprehensions and threatens the very foundation of democratic principles and federal structures. Sir, as already spoken by many, disrupting the triple chain of accountability jeopardizes the very essence of our democratic system and erodes the trust that the people repose in their elected representatives, sir. Sir, I think the most important in a democracy is the people. We must never forget that. Everything that we do here, everything that we do is only for the people.